It's 6:30 on a Tuesday night, the workday is over, and you hear that ping on your phone that you've got a work email, or maybe you get a call from your boss. Do you have to pick it up? Can you be fired if you don't? Hi, I'm Tom Spiegel with the Spiegel Law Firm. We help people who've been fired or afraid they might be in Maryland, Washington, D.C., and Virginia. Unlike some European countries, the United States, there are no laws that give an employee the right to what's called disconnect, right? Like basically after working hours to turn off the phone and stop answering it. There have been some laws proposed in New York City, California, I believe Washington State, but they haven't gone anywhere. Apparently we have grown to love our chains and are unwilling to disconnect from the phone. So in most instances, you do have to pick up that call or answer that email. There are some limitations, however, particularly under the Fair Labor Standards Act. You still got to pick up the phone, but you may be entitled to get paid for it or get paid overtime. If you are an exempt employee under the Act, basically it means you're at a certain income level, you're probably not in management. Fair Labor Standards Act can be a complicated law. You might want to talk to a lawyer about it. Don't rely on what your employer says. Employers misclassify people all the time. But if you are non-exempt, which means you have to get minimum wage, and you are entitled to get overtime if you work over 40 hours, answering that email is work, and if that puts you over the 40-hour threshold, then you are entitled to get overtime for it. Even if your employer isn't requiring you to answer the email, if they know you're answering the email because they get the response, you are entitled to get paid for that. The other law, which is a much smaller sliver of the population that this applies to at any particular time, is the Family Medical Leave Act. If you are on approved family medical leave, in most instances your employer should not be reaching out to you. So, if you're out with a new baby or you've just had surgery, you're on approved FMLA leave, it can be considered illegal FMLA interference for an employer to reach out to you, particularly to ask you to do work. But other than those circumstances, and even if you're under the Fair Labor Standards Act, you got to pick up that phone or answer the email. Otherwise, you could get fired for it. The other option is to find an employer that doesn't require you to do that. If you have any questions, put them down below. We'll try to answer them, and good luck out there.